Okay, ladies and gentlemen, welcome to the last session of today's Saturday Intent 2. Thank you all for coming. Thank you for supporting the Martha's Vineyard Book Festival. And thank you for everything you're doing to keep us all safe by being as socially distant and as careful as possible. We will encourage you, I am encouraging you now, and at the end we will encourage you again to go buy the books that you are hearing about here. It is my pleasure to introduce the three gentlemen sitting to my right. And this is a discussion, as you know, with Vernon, Burton, and Armand Derfner, along with Peter Edelman. So we're going to start with Peter. Peter is a lawyer, policymaker, and professor of law at Georgetown University Law Center. He specializes in the fields of constitutional law, juvenile justice, and poverty. During President Clinton's first term, he was counselor to HHS Secretary Donna Shalala. And he is the author of Not a Crime to Be Poor, The Criminalization of Poverty in America. Peter is currently chair of the D.C. Access to Justice Commission, whose goal is to increase the resources for civil legal services and to reduce barriers that prevent equal access to justice for low and moderate income D.C. residents. He is doing God's work in D.C. Vernon Burton, who is right here to my right, is the prize-winning author of several books, including The Age of Lincoln. He is the Judge Matthew J. Perry Jr. Distinguished Professor of History at Clemson University and Emeritus University Scholar and Professor of History at the University of Illinois. His research and teaching interests include the American South, especially race relations and community, and the intersection of humanities and social sciences. Armand Derfner, sitting in the middle, is a litigator specializing in class actions, especially in the area of labor, employment, and consumer law. He has been practicing civil rights law for 40 years as a staff lawyer for 50. This is what happens. You write your bio and then 10 years go by and you forget to update it. It's true with mine as well. He has been practicing civil rights law for 50 years as a staff lawyer for civil rights organizations in Mississippi and Washington, D.C., and in private practice in Charleston. Armand's focus on voting rights began with representing voters in Greenwood, Mississippi in August 1968, on the very first day the Voting Rights Act became effective. He has helped shape the Voting Rights Act through his Supreme Court arguments in several of the earliest cases, and he has testified before the judiciary committees of both the Senate and the House. His most recent book, co-authored with Vernon Burton, is Justice Deferred, Race and the Supreme Court, and it was published this May by Harvard University Press. And the Reverend Dr. William J. Barber says of Justice Deferred, it plumbs with magisterial sweep and resonant clarity the Supreme Court's wrestling with white America's commitment to the politics of domination. For 10 of our nation's 12 generations, no massacre has been too bloody, no injustice too stark for the court to defend. Excruciating legal battles have brought evanescent victories. It is hard to quote William Barber. Always, justice requires us to struggle against the sin of forgetfulness, and this book strikes a mighty blow, calling us to the struggles of our time and reminding us that higher ground awaits. To William Barber for his eloquence, and to our authors here for the upcoming conversation. Thank you for being here.
Well, that was better than I was going to do. All right. Everybody who is worried about the Constitution should be here. And the ones that aren't, bad. This is a very serious time, you get an hour here. I have to tell you, that's not enough. So read the book. Now that's, everybody's going to say that, but read this one first. And I have to, this is largely about race and our court. Yes, I was saying that we'll be talking about race and the Supreme Court a lot in this thing. And I just want to say, you said that this is interesting for people who are not lawyers. and you made it.
Right. We work really hard to make this book accessible for everybody, not just lawyers. And for example, the very first topic, the very first entry in the topical index is Hank Aaron.
Yes, yes, you made your point. Well, and what I wanted to say is it's terrific for lawyers too, and professors who teach about the Constitution, which is me. And I would be so much better if I'd had this book 10 years ago or 20 years ago, seriously, because one of the things that we, as the professors, tend to talk about the law and the theories and why was it there? What's the story? How did it get there? Well, this is what you get from reading this wonderful book. So let me just ask Vernon, how did this get started?
I'm going to take just 1 second, I promise, because I've already mentioned before that my thesis advisor and his wonderful wife, Lucy Hackney, who are role models, and we need them now more than ever. I think it's not just the Constitution we're worried about, but democracy itself and how the Constitution plays in it. But the last time I was here, we were doing the book in honor of Sheldon and the great civil rights lawyer who worked with Armand's sister, Kay. Parker Scheidler brought a copy, and I thought I would show it up. But I really, the Martha's Vineyard, I think it's wonderful you do this book fair, just extraordinary reaffirming at this time. But it also reminds me of civic engagement and the kind of things that Sheldon Hackney and Lucy call for and represent and their families have over the years. So I would be remiss in saying that. Well, I have to be honest, and I was involved when Armand asked me to write the book with him, but this conversation began in 1980, and we've been arguing and thinking about this book literally since the time when, as Yogi Berra would say, it's deja vu all over again. In 1980, the Supreme Court said it doesn't matter that laws discriminate, that they are set in a way so that black people cannot be elected in Mobile, Alabama. You have to show that it was the intention or the purpose of those laws. And with that, attorneys like Laughlin McDonald and Armand knew that's what historians do. They study motivation and intent. And I remember some of the wits writing at that time was saying, what are we going to do? Dig up the people in Mobile cemeteries in 1911 and say, did you intend to write that law to keep black people from doing it? So that's really where we started. And then in 2015, right, Armand? And it was the last time we both saw Bob Moses. We were at a place, Penn Center in South Carolina, and we'd been working on the book before that, but we sat down and outlined the book. Do you want to add more to that,
Well,
Armand?
yeah, the book, Vernon keeps saying this book's never been written before, and it could not have been written before, I guess, because the essence of it, I think, is that it's a historian and a lawyer together are writing it. And as Vernon says, that came to be around 1980 after the Supreme Court said we had to prove discriminatory purpose. And what we actually did is a group of the lawyers got a group of historians together, because historians are the people who go back into history, and we convened a 2-day conference in the old Biltmore Hotel in Atlanta. It no longer exists under that name. And we spent 2 days in 1980 thinking about how to do these and making plans for the future. And in fact, we gave it a nickname, the Biltmore School, and since that time we've heard a number of defense attorneys ask us about that as if the Biltmore School was some kind of communist cell. That's where we began talking about that. And so we've been talking and arguing about these things for 40 years.
Well, and here we are and have this wonderful, wonderful book. Let me ask you, Arnold, this is what you said in the book, so it could be either of you, but to get us started, because it's really the heart, at least one of them, in the book, and it says, quote, vexing concept of race with the perplexing Supreme Court and you have its book. Get us started.
Something else in the book grows out of that, and we probably might talk about that a little bit more later, and that is that judges have choices. We read an opinion, and the judge explains in the opinion why they reached that decision or why they want us to think they reached that decision. And so those choices are what court decisions reflect. And as Peter says, the point is that the choices down history, bad choices for racial equality in the 19th century, better choices as the 20th century wore on, frankly, bad choices mostly nowadays. Those are how the court treats these. It's sort of the intersection of race and the court.
Well, let me push you or add to that. The question of choice itself. Why do they have a choice? There's a Constitution. They read it. How come somebody can say, well, I have a choice, and you can do this or you can do that? How's that work?
Because words don't always mean the same thing. They mean different things to different people, different things at different times. And so, for example, the Supreme Court, not just a few years ago, said, well, money is speech, and not only is money speech, but you just about can't regulate speech at all because the First Amendment. Well, some justices think that's what the First Amendment means. A majority of the justices now apparently think that. That wasn't always the case. And so it's the same thing with questions like equality, discrimination, purpose. All those things mean different things to different people. And the question is, who's got 5 votes?
So, Vernon, somebody's got 5 votes. Isn't this really all about politics, and it's just got some blah, blah, blah language to go with it?
You know, that's a tough question. It's getting tougher, I think, to separate politics. But politics have always been involved. But to follow up a little bit with Armand's question as well as answering yours, I think of a good example of this is the 13th and 14th and 15th Amendment changed the Constitution. And I like to say that Abraham Lincoln basically took our mission statement, Declaration of Independence, and put it into our rule book, the Constitution. And yet, for a long time, certain justices thought of the Constitution as forever in terms of states and what was then called federalism in the sense of the states' rights and could not accept that interpretation. But yesterday in our panel, Peter, I love that we started with the idea of we the people. Again, Bob Moses, as the Constitution starts with we the people, and that means something, I think. And it also means something. You have 3 branches of government, which I think we sometimes forget, that are there to balance and counterbalance each other, that we the people have to do something. And that goes in with how people understand and interpret. The most interesting thing to me, though, is those times where the politics of a judge, you would think, would be very different. And you think of Justice Harlan, the great dissenter who supports the Confederacy and becomes a champion of African Americans. So it's not always the way you think the politics might run. And I do believe that judges learn from the law. There is a great oral history, very long, of Judge Waring, who is the first federal judge in Charleston, South Carolina. In the Clarendon, South Carolina case, it sort of evolves into Brown v. Borders, the central case, and one that Thurgood Marshall answered. If you read through that, he says that as I read the law, as I was the judge in the law taught me. So I think there's hope there if people pay attention to the words and we the people and what those 13th, 14th, and 15th Amendment and other amendments are saying as well.
Mm-hmm. Mm-hmm. Armand, do we need to go up up the water where the beginning of this, what we're saying here, where do those justices come from, and what difference does that make?
Well, it's interesting. In the old days, they came from lots of different places. They came from practicing law. They came from politicians. They came from every different part of life. Law professors. Now they seem to come from federal courts of appeals. Eight of the 9 justices today were federal court of appeals judges. And part of the reason that's true today is that the president wants to know, what will this justice do? In other words, it's not simply Republican and Democrat or whatever, even though it often turns out to be that way. But what will the justice do? What is the justice's view on questions like equality or freedom or liberty or all the words that are in the Constitution that aren't defined? And so if they come from the Court of Appeals, then they know what that judge has done. I think somebody once said, I'd feel a lot more comfortable if we had somebody who'd ever run for a dog catcher. We haven't had a justice who was a public official since Sandra Day O'Connor, which is 40 years ago. And of today's justices, none of the justices has ever spent substantial time in private practice. They come out of law school, they become a law clerk, they go to work for the federal government, the U.S. Senate, or the Justice Department, or something, and then they become a judge and then a justice. Very few have had any other kind. So if we really want some diversity, we need a lot of different kinds.
So you're saying it's not in a place that you think is good, right there?
Not on that.
Oh, okay, well, we'll check about what other
Plus, they're all, I think, 8 out of 9 are from Harvard and Yale. And even though that might suit you or me, having been to both those places, it's nice. I don't necessarily like the newest justice, but at least she's from Notre Dame.
But
okay,
they're all members of the Federalist Society, the last 3 too, though, and I think that gets back to the politics
Yes.
of the creation of groups who've studied how judges have ruled and the surprises that some saw, and they wanted to be sure of certain principles that would.
Is it part of the structure from the beginning that it's supposed to be this way? In other words, you have in the earliest part of the 20th century, especially right before FDR, as we know, very, very conservative, basically 5-4, losing. And then FDR, as we know, comes to a very liberal. And in the 60s, I mean, you get Arthur Goldberg, who I clerked for, and Fortas as well. Is this all the way it should be as a structural matter?
What do you think?
This is tough. We know that it can work, but it can work for good or bad, depending on what you're looking at. The main thing I think you want to be sure of that is you have a rule of law. The problem is that people are interpreting the law, which has extraordinarily political implications as well as implications for equity, for freedom even, and to have the same opportunities at the table, particularly in voting rights. So it gets very tricky. It certainly can work. And I have been surprised and pleasantly surprised to see that some people who I thought would not be a judge who would rule fairly in things actually could make those incredible changes and try to do what was right.
Sometimes it's like a lottery. In other words, some of the worst period in the Supreme Court's history is the Reconstruction era. And the justices on that court were almost all appointed by President Lincoln and President Grant. And yet they came up with these god-awful decisions. In the modern era, one of the best justices, one of our heroes, Charles Evans Hughes, was appointed by William Howard Taft, who generally does not have a great reputation for a lot of things. And a lot of justices in the New Deal, as you say, were appointed for lots of other reasons. They were appointed for economic reasons in Roosevelt's time, and yet that was the time really when things started to really look up for the first time in race relations. And I'll just say the last thing, Or when Earl Warren, we all talk about the Warren Court, when Earl Warren was named Chief Justice, it's true he had a generally liberal reputation as governor of California, but as Attorney General of California, he was one of the strongest people urging that every person of Japanese descent on the West Coast should be in a detention camp. That was Earl Warren.
Yeah, absolutely. Well, certainly we can say right now, anyway, that from the beginning there have been people on the court who don't have the politics or their views that one might expect it from that president until now, essentially. So just to make that note, unfortunately.
It's changed.
I hope it hasn't all changed. I still have some hope. When you mentioned Justice Hughes, who we've really become fascinated with and are going to do some more work on, he was great on race, but there were other issues that weren't there. But he was motivated. His father was a American Baptist minister, and he was a devout American Baptist, and they were very good on race, and he stood for those issues. Now, you talk with some other people in terms of perhaps taxation or corporations, he might not have been as good, but certainly on race was. And I think there are times that people are complex, and they can be motivated by other things than even politics, and sometimes it can trump politics, I think.
We may be giving an impression that a lot of this is haphazard and just a question of luck and timing. But in fact, one of the things we do in the book is see a thread that goes through the bad times and the good times and now the bad times again. But there's a thread, and the history makes a huge difference. The history of the past comes up in the present. The Reconstruction cases come up in the civil rights movement, etc. So although we're talking about a lot of things that are helter-skelter, one of the things that we try to do in the book is to draw a thread and to show the threads, not necessarily that the cases come out the same way, but that some of the issues are the same, some of the hard things to decide are the same.
And let me add that one of the things as a historian is the importance of contingency, that it could go a different way. And that's one of the things I think we show pretty well that you might not get in a normal book by attorneys or others. And that is that there not only were there choices, which is a theme of the book, but the way things developed, the timing of things made a huge difference in what the court did and what they decided, particularly for racial justice or not.
One good example of that, which you're familiar with, Peter, is in the early 60s, all the southern states were attacking the NAACP in different ways, demanding membership lists, prosecuting the NAACP, doing all kinds of things. The Supreme Court rejected every one of those for several years, and then in the early part of 1962, there were two cases before the Supreme Court, and there were tentative votes that had been taken in which the 5-4 majorities on the court had decided against the NAACP. If those decisions had come down that way, a good part of the civil rights movement would have been crippled, early 1962. Those opinions were written. We've got the drafts. We've got the majority opinions as drafted. And then suddenly, in 5 days in early April of 1962, 2 of the 5 left. One had a nervous breakdown on the 1st of April, or left on the 1st of April. Another one had a massive stroke on the 5th of April. Those 2 acts of God, you could say, led to 2 new justices.
Say the names.
The first one was Justice Whitaker had a nervous breakdown, and Justice Frankfurter had a massive stroke. President Kennedy was in charge, was president, and this, I guess, ties in with the last thing we've heard about from Pat Sullivan, but President Kennedy named Arthur Goldberg to fill one seat, and Byron White, vice versa. Byron White to fill Whitaker's seat, Arthur Goldberg to fill Frankfurter's seat, and when the dust settled 6 months or a year later, the 2 cases came down the opposite way. The NAACP won both cases, which they would have lost, and it made a huge difference in what happened compared to what might have happened.
Let me give one other contingent example.
Do
and that-
2, 3.
No, we'll get on to other questions, if that's okay. Thurgood Marshall had joked that he was not going to retire, that, of course, he was going to die shot in bed by a jealous husband. But then he was really in bad shape, and this is contingency. It looked like there was no way that Bill Clinton would win the election when Thurgood Marshall is suffering and things like this. He's popular right after the Iraq War, the first Iraq War, and so Thurgood Marshall retires, and to replace Thurgood Marshall, you get Clarence Thomas. And fast forward to the election of 2000 and Florida and the decision there. I mean, that would have been a very different decision there, and there would not have probably been a second Iraq war. I mean, it's amazing how these choices and coincidences of history matter, and it all comes down to one of the central things: votes matter. The presidency is a winner take all, and they get to appoint not just those justices at the Supreme Court, but at the federal court levels for life, where we argue some of these cases that finally come up to the Supreme Court. So the one emphasis is so important is voting, and how your own vote makes a difference ultimately, not just in the lives of people now, but in the future.
I'll just tie that together to Pat Sullivan's book. Of course, the most significant change in Supreme Court history, of course, came after the shooting of Robert Kennedy. In the 1968 election, which a year or two earlier, nobody could have dreamed that there would have been a change. But there was, all that was going on in the late 60s, and President Nixon won the election. But he got 4 appointments in his first term, almost more than almost anybody else. One of those appointments was William Rehnquist. William Rehnquist, as a law clerk in 1952, was on the court when the school segregation cases were being argued, and he wrote a memo to his Justice Jackson, saying, I believe, I have been criticized as unhumanitarian for this, but I believe Plessy versus Ferguson was right and should be reaffirmed. Well, 20 years later, he came on the Supreme Court, and he really has been the dominant force ever since. He was on the court for 35 years, 17 as Chief Justice, and now the Chief Justice today is John Roberts, who was William Rehnquist's law clerk.
And let me add, and then we'll give it back to you, Peter, if that's okay. Thurgood Marshall, who won against all odds, all the Supreme Court cases that no one thought could be won. He was such a brilliant, and then he gets on the Supreme Court and he's on the losing side, over and over again. But 1980, the election when Reagan wins, and we can go into a lot of this other thing, but there is a scene that, to me, is hard to even describe without breaking into tears. Justice Brennan comes up to Thurgood Marshall, and Brennan is a small man, and Thurgood Marshall was a giant of a man. When Thurgood Marshall was being confirmed for the Supreme Court, Strom Thurmond just gave him the Dickens. I mean, just grilled every kind of thing, communist, everything else. So Brennan, his friend, and really the two of them, that's really probably why he retires. His last friend's gone. Brennan said, I can't believe it. Is Strom Thurmond really going to be chair of the Judiciary Committee? And the Thurgood Marshall puts his arm around him. You can just see it. It's a vivid image. They turn around, these two old warriors walk back to their chambers with his arm around Brennan as they go off to fight their last battles for justice, really.
Getting to a lot of stories, wonderful stories, and important in terms of the structure and how
They all fit.
Absolutely. Let's go back to something that is to you, and I think everyone should, and 3 or 4 pieces of the Constitution and what's happened to them. And the one that you say kind of at the top of the list is the 13th Amendment. And you say to the heart of the Constitution. The 13th Amendment is the heart of the Constitution. Now, I could make an argument that it's really important, but we kind of like the 14th and the 15th, too. So could you tell us why you make that statement?
They're all part of the same process. We call them the Reconstruction Amendments. Some people call them the Civil War Amendments. They came together within the space of 5 years. But the 13th Amendment, especially from the point of our nation's original sin, the 13th Amendment was a new charter of freedom. And everybody recognizes that the 13th Amendment not only ended the institution of chattel slavery, but also was designed to end all the badges and incidents of slavery. And we think that includes all kinds of things, including racial discrimination itself, which grew along with slavery. And so we think of the 13th Amendment as a charter of freedom. And the most important thing is we say, I guess we say this a few times in the book, it was not simply a one-time historical event, but is a continuing promise, still unmet, and one that we still have to aim for.
That, of course, relates to a very terrible time after the Civil Rights, Civil War, and as we know, by 1877, there had been an enormous change in the other direction. So it's not only the 13th Amendment, although that's very fundamental. And I wonder, maybe Vernon start, and maybe both of you,
Yeah.
but something that you talk about, and maybe not so that you all would know. In 1876, there were two horrible cases. One was Crookshank, and it's a massacre in Louisiana. And it had to do with essentially the federal government and the local, and these people are murdered, and nobody does anything about
150 of them.
150 of them, that's right. And on the same day, United States Reese, which is about voting, which also takes us in the wrong. So tell us, both of us, how that change. When I teach that, I don't do a good job of that. I mean, I do my best, but
You do a great job.
but it's really great now.
No, well, thank you. What I'll do is do the historical context, but one other reason that we emphasize the 13th Amendment, look what the court has done to the 14th and 15th Amendments. And it's interesting because I don't see how anyone can look at the 14th and 15th Amendment and not realize that this was done for a group of people who had been enslaved all of this time. And yet, 85%, I think it was the last numbers of all cases that have been 14th Amendment have been for corporations as persons. And then the idea that white people are using the 14th Amendment to sue against affirmative action. So, and the same thing, we could go through the fifth. So I think the 13th Amendment is still there, and it was reinforced in, was it 1967 or 69? 68. Well, I was right between it, right? Average it out. And it was reaffirmed that it's still there in terms of the badge of slavery. And it is specifically geared toward those people who'd been enslaved. That's another reason that we have it. The Colfax Massacre was a horrible incident in which, as Armand said, 150-something people about that were killed. We don't even really know how many, but the Republicans, white and blacks at the time, but I believe it was only blacks that were killed, were in the courthouse. They brought in cannons. They shot them down, and the initial court, found some things until it got to the Supreme Court. And I'll turn that over to Armand because I think he can describe the cases better. But one of the amazing things I think people hadn't put the link to is this. After Mississippi overthrew this interracial democracy, and it's a coup d'etat. It is, no other way to say it, in the United States, a legitimately elected government was overthrown by a terrorist in the United States. But 1875 is Mississippi. Then you have in South Carolina, Louisiana, and Florida are similar. And I don't think people had ever realized before, but the Colfax decision comes down, which I'll let Armand explain, which says you can murder black people and get away with it with a little bit, and this goes to your issue of what the words mean, or interpreting the laws broad or narrow. And that's exactly what they did. It was like sanctioning murder of people. And after that, you have the Hamburg Massacre in South Carolina, and there's evidence. These were attorneys who are leading this. They are reading these court cases and knowing what they can do and not do with a terrorist campaign.
In the early 1870s, when Reconstruction was really working, part of the reason it worked was that the federal government was bringing prosecutions under something called the Ku Klux Act. In the year 1873, there were 1,200 civil rights prosecutions. They drove the Klan out of South Carolina. And here in 1876, the Supreme Court says, no, the federal government does not have the power under the Constitution to prosecute Klansmen for killing people. So that really meant, that sort of opened the field to just, as Vernon says, go ahead and murder.
And that's what happened immediately in South Carolina right after.
And in fact, I'll just add one thing. If you go to Colfax, Louisiana today, which is in western Louisiana, it's in Grant Parish, the parish named after President and General U.S. Grant, and the town named after Speaker of the House Schuyler Colfax. You will see a monument still there today that says, here's this monument. This was where the carpetbag misrule of the South ended. That monument still glorifies that massacre today.
And a picture of it's in the book. It's one of the illustrations.
Oh, you want to stop for a minute over that? That is just, well, we know, it's just horrible. Going newer to now, once you start, where are we on Brown and Board of Education? There's segregation right now, as we know. Did we mix? Did we do a bad job? What do you think about it?
We found other ways to segregate it, and people knew. But when you mentioned Brown, one of the things that I like about our book, we tried to give due justice to a group of some of the greatest heroes that's ever come out of the United States who've never been recognized. In Little Somerton, Clarendon County, Reverend Delaney not only risked his life, his home was burned, his church was burned, he was shot at, and he had to flee the state as a criminal. And yet his love for South Carolina was so great, we don't seem to understand. He moved back to Charlotte. He couldn't go back home because a warrant was still out for him, even when he died. After he died, they got rid of the warrant. That didn't do him much good, did it? And these people, this is the case. It was a deep South, or at least a South Carolina community of everyday folks who risked everything for their children, all over a school bus. It's a more complicated story and thing, but with Brown v. Board. And it reminds me, Peter, I was they weren't quite sure when Ben Mays was born, but Dr. Benjamin Mays, the longtime president of Morehouse College, his autobiography, Born to Rebel, and I was, I believe, the only person who was not African American there. And a group of particularly young people stood up, and they were saying we were better off with separate but equal. And I know the pastor of one of the largest black churches. And I kept looking around, so I felt particularly awkward being the only white person to stand up and said, but we've never had integration. We haven't given it a try. But here's what segregation is, and that's what we try to explain in our book. But what's happened is the court has allowed, in fact, the court spoke up to stop school districts who wanted to try to find ways to work around segregation. So it's complex. There's no doubt that if it were ever equal, but we know how power works, it may have been different. But that's not going to happen, I don't think. And the law, if we're going to have a law, then I think it has to be equal for all people. And, Derek Bell, of course, argued that Brown was wrong that way too, but it has not been enforced. But the main thing that we do in our book is try to show, in fact, that the court has been complicit in the resegregation of America.
Yeah, if you look at Brown at its time, what we had was a system of Jim Crow, not just in the South, but it really affected the entire nation. And Brown said that's wrong. What Brown did, in effect, was not a revolutionary new thing. It was as if it were 100 years or 90 years before. The 13th, 14th, and 15th Amendment, which started out with Reconstruction, should have moved on. There should have been a Brown right then.
Right.
And if there had been, we'd have been progressing from there. Instead, what we had was a late Brown, sort of a redo, and we've been struggling ever since to try to move forward.
And I do think there's a generation divide. When I made that statement at Morehouse College, it was sort of everybody my age and older sort of agreed with me, and all the younger people who really hadn't grown up under segregation, under knowing what segregation really was in the South, felt differently. So I do think there is a generational divide on this.
One of the points we make in the book is that we had 12 generations in this country of slavery and Jim Crow. And that was 12 generations of law and custom in every single state. At the time of the Revolution, every one of the 13 states had slavery. And it went away very slowly. There's a national amnesia. People sort of forget what there was. But what we had was 12 generations of slavery and Jim Crow. We've really only had 2 generations since that time to get over it. And what is deep planted, nailed in for 12 generations does not disappear overnight. And so if you're asking about progress, I'll point to Vernon's chair. The chair is named after Judge Matthew Perry, one of the great civil rights lawyers and good friend of both of ours. And I remember sitting at lunch one day with him in the 1990s, and him saying, "I have seen things happen that I never dreamed I would live to see." And so we need to be aware both of how far we have to go, but we really have come a long way in 2 generations. We just need to keep on going.
Let me open up here. Great law, yeah. Because there's so much here, and so let's get you into it. If you don't say anything, we've got 1,000. You can. Okay, please. Sure.
Will you let me know if you can't see the people asking?
Okay.
Can you see them? Okay.
Yeah, you got to be tall. Stand on your tippy toes.
You look like a tent pole.
So, well, they know who I am. But I have been
Oh, so
dying
this is a
to
trick
ask
question.
This question. I've been holding it in. One of the famous lines from Brown versus Board of Education is the court saying, segregation will injure the hearts and minds of black children in ways that may never be overcome. Could we today find white plaintiffs who would go to the court and say segregation harms the hearts and minds of white children in ways that may never be overcome? Because we're dealing with the injury of white supremacy.
I actually think there are white parents who are saying that. And in fact, 2 of the court cases we discussed, the Supreme Court stopped school boards from trying to have integration at the time. I was on the amicus briefs, and I'm blaming Louisville and Seattle. It's too bad when you're on an amicus brief and can't remember the names.
Age.
Well, maybe other things too.
It's pretty terrible.
Yeah. But I do think so, and I think that's a truism. Of course it did. It not only injured, but it injured the particular the South, and now with the black population particularly spread and other minorities throughout, and the segregation we have, of course, is hurting white children. We live in a if you don't want to be an idealist or take it from a theological perspective that perhaps I do, it's just common sense. We live in a transnational world now. And if we don't understand and deal with other people and understand the differences in how we think and how we work together, we're just losing out badly. And that's the white community, I think, that opposes these things.
There's several Supreme Court opinions in which justices that we call conservative, particularly Rehnquist and O'Connor, have both talked about how segregation is really harmful, and it's harmful to people of all races. The ironic thing is that those statements have come only in cases where white people are saying they have been discriminated against, and I have never seen them make that statement in a case where blacks were claiming discrimination.
Okay, other questions?
Do you think that with
A little louder, just.
okay,
Yeah.
how's that? Do you think that with the elevation of Justice Barrett and Kavanaugh to the court, that will act as an accelerant to Justice Roberts being more moderate, and the same for Gorsuch? And in the line of discussion that you had before, that in the great book Linda Greenhouse, Becoming Justice Blackmun,
Right.
will we have some surprises there coming down the line, in your view?
It's impossible to tell, but as I say, they try to pick justices whose positions are predictable. And when justices change, Justice Blackmun was an unusual example of a difference. But oftentimes when we see justices who seem to have changed, it's often because the issues have changed. So we have no idea, but I wouldn't be very sanguine about what this court is going to do on race relations or some other things. For example, the voting case just at the 1st of July, the Bronovich case, was an awful case, basically going far toward destroying the right to vote.
Yeah, and I think on voting rights, it's been pretty well screened, I fear. There may be other issues where it could make a difference. I'm not, our emphasis and where I've put my life's work as a historian has been studying race and race relations. But there are other issues that it might make a difference. And in the conclusion, Armand and I went back and forth as we wrote about this idea of originalism and who's an originalist. So if they really are originalists and they read the 13th and 14th and 15th Amendments, and like Judge Waring, maybe they'll learn the law. And they'll learn that they will follow the principles of the law, which is what they are committed to. And if there's some people there who are committed to a certain faith belief, it seems it would be hard for them to rule certain way. I'm not sanguine like Armand, but I don't want to give up hope. And it has happened before, so we don't know. But the voting rights one is right now is the most stressful, at least for me.
It comes back to choice, which you talked about at the very beginning. Judges and justices have choices, and the question is, will they interpret certain provisions for the most they can be, broadly, or for the least they can be? And as I said, some of the justices called conservative now, they interpret the First Amendment very broadly for money. They interpret the First Amendment and religion very broadly for allowing big companies to have religious beliefs. Well, you would think that the 13th, 14th, and 15th Amendment, this is what we say in the conclusion, for which a horrible civil war was fought, certainly ought to claim a broad reading.
I just have to say, we're in deep trouble.
Yes.
And there's 5 people who don't believe in anything except do terrible things. And you've got one Chief Justice who now and there, and of course, they don't need him. And so he can look good because they don't need him. And he likes it for history that he got this one and that one, and is sort of a nice guy. We're in deep trouble.
He's not a nice guy on the Voting Rights Act, that's for sure.
completely, I don't want to
Yeah,
say
no,
anything
no,
nice
no.
about it. I'm
Well,
just
no,
saying, I'm just saying the way he plays it.
Yeah.
And he wants enough there, and look what he does for business. Woo!
Yeah, exactly. 14th Amendment.
Yeah.
Well, in light of the doom and gloom that exists, could you opine from both a historical and a legal perspective or court perspective about the possibility of having more justices on the court and sort of, because that was a big issue like 6 months ago, and it's kind of, we haven't talked, I mean, it's faded.
Yeah, no, good question.
And of course, most people don't know that it's varied over time.
Right.
I mean, that it's the number of justices have.
It went from 6 to 5 to 6 to 7 to 9 to 10 to 7 to 9 is how the number has fluctuated over the years.
But just remember what happened to Franklin Roosevelt.
Yeah, and hopefully, well, we'll do that. Let me just take a second. I'd like to read the last paragraph of the book, which addresses that and what I think to the issue you're really getting at. Should President Biden try to expand the number on the court? And I think he's doing it right now in the sense that he's trying to work every way possible to get things done. But if he can't, he's going to be in the same situation Franklin Roosevelt was in. So we'll see. But Abraham Lincoln challenged us, determine that the thing can and shall be done, and then we shall find the way. That's my little lesson there. But we take inspiration from the young people who will be writing the next chapters. In 2019, 2020, the U.S. Youth Poet Laureate Amanda Gorman gave readings around the country of a poem she had been commissioned to write for Independence Day. In her performance at the American Academy of Arts and Sciences, Gorman, an African-American woman from Los Angeles who was a student at Harvard, explained that she sees American democracy not as something that's broken, but as something that's unfinished. Rather than falling prey to discouragement, she speaks of being audacious in taking up the mantle of our founders and playing her role in finishing their work. In her poem, Believer's Hymn for the Republic, she declares, every day we write the future together. And it's a different future. We mentioned in a panel yesterday, the demographics of this country are changing. And I have been really inspired by young people. Despite as bad as things seem to be on the court, I think young people don't want to be racist, and they don't want racism, as long as a lot of other justice systems they care about. So I don't want it to be all depressing. And I think part of why we're getting all these laws and bad decisions is because this world is changing, that Texas is already a majority minority. I'm involved in one of these Florida voting cases right now, and it will soon be, at least by 2030 probably. And so you get a sense of the desperation of people trying, instead of upholding the law itself and the rule of law, of trying to use the law to maintain power. And I think that's where we are. I'm sorry to say it that way, and I hope I'm wrong, but I really think that it is desperation at a time when America is under a great challenge and changing time.
I just have a really quick question, really quick. Thank you for
We
this.
got time.
Okay. Why do they have to be there for life? Why can't we say they're there for 6 years, let's say, and then go? I mean,
They used to not be there for life, most
Right.
of them.
When did that happen? When did they get there for life?
The Constitution
And why?
says that they're there for life. There have been proposals to reduce that to, say, 25-year terms. But this is what Vernon says. It's interesting. Well, no, it's not just that it's so long. Life is longer than it used to be.
We actually did the
olden-
statistics on this. in
Yeah,
the
we
book.
did statistics that show that 50 years ago, the average term of a Supreme Court justice was 13 years. Some of them died, some of them retired, some of them left for other jobs. Now it's more than 25 years. So whatever damage a Supreme Court justice could do then, it's worse now.
Can we change that?
Change the Constitution. Just find 36 states, or 38 states, I guess, to agree with you.
Yeah. You just ask the women's rights movement and ask a few
Right.
others how easy it is to change the
You remember,
Constitution.
the Equal Rights Amendment was doing fine in the 1970s until Phyllis Schlafly came along.
But that's a good example of why you need to organize, and goes back to voting. It's the only way, as I can see it. And people do respond to the vote. Even though they're trying to change it, you don't have to respond to the vote. Hopefully the Supreme Court won't go along with that.
We have three branches of government, and the Supreme Court shouldn't be in charge of everything.
Then why is it?
Because it's in the Constitution.
But Congress can amend the Constitution or laws, and then we have a chance.
Is anybody trying to do that right now?
They are. I mean, there's a John Lewis law and the others, so there's a lot going on. How successful it's going to be is going to depend on you and me and everybody else
I think
organizing, voting, and writing congressmen and senators.
All of us were a lot more optimistic till about 6 months ago.
Yeah, we went through a crisis.
What do you mean?
Go ahead.
Well, we had no idea that there were this many millions of Americans who are ready to believe or say they believe in the, quote, big lie, and how so many people who are ready to go to any length to destroy democracy. We thought democracy would work, and I still believe it will, but I'm not sure I can explain why I do.
Last
Actually, you just introduced my question. Thank you. In Jane Mayer's article in the New Yorker about the big money behind the big lie, I can't remember who this is attributed to, but there was a statement that made that sort of the logic behind the sort of most of the upset on the conservative side is that I mean, really only white people are real Americans, and everybody else is something else, and that is the driving energy. If people who believe that are using the law to basically sort of reinforce their belief system, and actually in some instances sort of try to change history, how can those of us who understand that that is wrong use the law to promote truth and justice and equality?
Organize and work. Organize and work. And remember a couple of things, okay? I understand why a lot of people who seem to be opposed to the future are opposed to the future. They think it's not for them. This country 50 years ago, 1960s, was 80% white. Now it is 60% white. We have 1 million immigrants, legal immigrants a year, and 10% of them are white. We have close to 1 million new citizens a year, voting citizens, and 10% of them are white. So I guess this is sort of facile to say, but they can only hold the tide back for a certain amount of time. If you organize and work, I think we will get there.
And I also believe education, though. I really believe that education is central too. I think a lot of people are being sold a bunch of bull, and they believed it. And the only way is through education, and we've sold short democracy's education. We really have.
And I'm going to have to be the bad one who has to shut down this fabulous conversation. Thank you so much. We still have bags available. Don't let tomorrow's people buy the bags. Get them now. You want to step in? Thank you all.
Just one final word. It's been a terrific day, and I appreciate so much all of you being here. We are particularly honored to have this panel here. Here you have the real powerhouse behind the work, the hard work. When they say organize and advocate, these three men have done more for organizing and advocate than you can possibly imagine. So it's really an honor to have their voices here today. So I thank them so much for the work that they do and for joining us. They both traveled all the way from South Carolina to be here. And the book is available, Justice Deferred is available for sale, and I think that Don's carrying one there, encouraging you all to buy it. And come back tomorrow, and we will see you then. Thank you for a wonderful day.